Good morning, everyone. This is Rajeshkumar. Today, we are going to see one theory question on past consideration and as well as one problem question on the same topic. Disclaimer, the video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. The past consideration is never a good consideration. We have to discuss in detail about this. Charles and Devi own a dental practice. Devi is in a relationship with Charles' sister, Erin. Charles tells Devi that he will pay for their honeymoon if Devi and Erin get married. Unknown to Charles, Devi and Erin are already engaged when this promise is made. After Erin and Devi marry, Charles is annoyed to discover that they did not tell him about their engagement and refuses to pay for their honeymoon. We have to discuss whether Devi can enforce the Charles promise to pay for the honeymoon. The principle that past consideration is never a good consideration refer to the general rule in contract law that can act performed prior to the promise cannot be used as valid consideration to enforce that promise. This principle was solidified in Roscorlo versus Thomas in 1842 case, where a buyer of a horse sued the seller for breach of a promise that the horse was sound and made after the sale. The court held that the promise could not be enforced because it was based on past consideration. The sale had already occurred before the promise was made. The principle of consideration is fundamental in English contract law, and the general rule is that past consideration is not a valid consideration. For the consideration to be valid, it must be bargained for at the time the contract is made, rather than something that has already been performed. However, there are exceptions where past consideration can be deemed valid. This rule emphasizes that consideration must be contemporaneous with the promise. The past actions or services cannot form the basis of a future promise unless an exception applies. The exception to the rule on the past consideration, uh, one such exception arises where the past act was done at the request of the promiser and with the exception of later remunerations. This exception was established in Lampilogue versus Brathwaite case in 1615, where a Brathwaite, after killing a man, asked Lampley to seek a pardon for him. Once the pardon was secured, Brathwaite promised to pay Lampley £100. The court held that the promise was enforceable because the earlier act, the securing the pardon, was done at Brathwaite's request, and there was an implied exception of the payment. Similarly, in Recase Patent's case in 1892, a defendant promised to remunerate the case for the work already performed on patents. The court ruled that although the act had been completed before the promise, it was enforceable because there was an implied understanding that Case would be paid for his efforts. The court's reasoning aligned with the doctrine of implied promises, particularly where the parties had a contractual relationship. The test for when the past consideration can be valid is summarized in Pawn versus Love Eve Long case in 1980. Lord Scarman set out the three conditions. The act must have been done at the promiser's request. The parties must have understood that the act would be remunerated. The promise would have been legally enforceable had it been made before the act. So let's conclude why the past consideration is not typically valid. The exception provided by Lampe case, the Recase case shows that it can be valid if the act was performed at the promisor request with an exception of the payment. Therefore, the statement that past consideration is never good consideration is only true in a general sense, but significant exceptions apply. Now let's move on to the problem question. Can Devi enforce the child's promise to pay for the honeymoon? In this scenario, we must examine whether the child is promised to pay for Devi's and Erin's honeymoon is enforceable. The key issues are consideration and the intent to create a legal relationship. In Jin's case, the general rule would suggest that Call cannot enforce the Jin promise to pay the 10 pounds for cutting the lawn. So, the considering the pre-existing obligations, a child's promise to pay for the honeymoon was made when Devi and Erin were already engaged, which raises the issue of whether Devi provided any valid consideration for Charles' promise. The case of Shadwell versus Shadwell in 1860 is relevant here. In that case, an uncle promised his nephew money if the nephew married. The court held that nephew's marriage, which was already planned, constituted a valid consideration because marriage involved legal obligation responsibilities. Similarly, even though Devi and Erin were already engaged, their subsequent meeting, the subsequent marriage could be seen as consideration for Charles' promise. So, what about the past consideration? The engagement between Devi and Erin was already in place when Charles made his promise. This raises the issue of past consideration. But under the principles outlined in Shadwell versus Shadwell, a marriage can still count as consideration, even if planned beforehand, since it involves entering into legal obligations that would not have existed otherwise. The general principle is that consideration must be something of value and it must move from the promisee, a pre existing legal obligation, or a prior arrangement typically cannot constitute a valid consideration. In Shadwell versus Shadwell case in 1860, an uncle promised to pay his nephew an annuity if the nephew married his fiancée. The court upheld the promise, reasoning that nephew's marriage, though a pre existing obligation, still constituted a good consideration because it was beneficial to the uncle. In Charles' case, even though Devi was already engaged, the marriage itself could be considered a good consideration, as it might be deemed beneficial to Charles, similar to the reasoning in Shadwell versus Shadwell. Therefore, Devi's marriage to Erin could provide sufficient consideration to enforce Charles' promise to pay for the honeymoon, even though the engagement predated the promise. Rather, engagement predated the promise. Intention to create legal relationship. A domestic and social arrangement. A crucial question is whether Charles and Devi had the intention to create legal relations. Traditionally, the agreements made in domestic or social context are presumed not to have this intention, as in Belfer versus Belfer in 1919, where a husband promised to pay his wife was not enforceable because it was a social agreement. However, in Coward versus Mim in 1962 case, it was held that a promise between the both colleagues can fall outside the domestic context. Since Charles and Devi are the business partners and not just family members, the presumption against a legal relation may not apply as strongly. Additionally, the nature of the promise, paying for the honeymoon, suggests that it was not merely a casual or a social arrangement agreement, but rather a serious promise. Moreover, Payman versus Lanjani in 1985 case reinforces the idea that in a business settling, parties are more likely to intend for their promises to have a legal consequences as opposed to a purely domestic arrangement. In other words, another key element is whether the child's promises was intended to create legal relations. Generally, social and domestic arrangements, particularly between the family members, are presumed not to create a legal relations, as demonstrated in Belfer versus Belfer 1919 case, where a husband promised to pay his wife and allowance was found and unenforceable due to the absence of legal intention. Similarly, in the Coward case, an agreement between the friends to share the transportation cost was held to lack the intention to create a legal relationship. However, this presumption can be rebutted, especially when there is a formality or the clear evidence that the parties intend to bound legally. In Marriott versus Marriott case in 1970, the court distinguished Belfer by holding that a separated couple's arranged agreement regarding the financial support was enforceable because it was made with the intention of creating the legal obligation. So, applying these principles to Charles and Davis' case, it could be argued that Charles did not intend his promise to pay for the honeymoon to be legally binding, particularly since it involved a close family members. The court would likely examine the context and whether there was any clear evidence of legal intention, such as the written documentation or formalities. If no such evidence exists, it is possible that the court would follow a Belfer case and find that a promise was not intended to create a legal relationship, making it unenforceable. It could be seen as a valid consideration based on shared well versus shared well. The critical issue is whether Charles intended to create a legal relationship. If the court finds that Charles' promise was made within the social and domestic context without such intention, Devi may struggle to enforce it. If, however, formality or context suggests otherwise, Devi could succeed in enforcing the Charles' promises to pay for the honeymoon. So let's conclude. Devi may be able to enforce the Charles' promise for the following reasons. Under the principles in the shared will as a shared will, Davis' marriage to Erin could constitute valid consideration even though they are already engaged. While domestic and social arrangements typically lack the intention to create the legal relationship, the fact that Charles and Davy are business partners weakens the presumption against enforceability. There are strong arguments that Charles' promise was intended to have a legal consequences, especially given the significance of the promised sum for the honeymoon. Thus, Devi may have a strong claim to enforce Charles' promise to pay for the honeymoon. However, Charles could attempt to argue that the promise was made in a social context, but this argument is likely to be a less persuasive given the business relationship between the parties. Thank you.